Good morning, Your Honour. I seek leave to appear on behalf of the applicant. Your Honour, the applicant will be seeking an order that certain evidence be excluded on the basis that it is inadmissible, or in the alternative, that you Honour exercise your discretion not to admit the evidence pursuant to discretions provided in Bunning and Cross and Christine and Crown. Firstly, Your Honour, my submissions as to admissibility. We seek to have the omissions in the recording made inadmissible on the basis they are not relevant to establishing any of the elements of the charge the accused has been charged with, and that there has been a breach of statutory provisions. As per McKinnon, some of these omissions have no rational bearing upon the elements of this charge. The omissions I refer to are intending to sell drugs, his gambling addiction, and his dire financial situation. However, Your Honour, these omissions are likely to have prejudicial effect on the client if shown to the jury. Your Honour, I will now draw your attention to Section 418 of the Police Powers Act and Section 10 of the Criminal Law Amendment Act. Both are very similar in their wording. A police officer must obtain a confession by threat or promise. The first element of these two sections has been satisfied, as they are police and they are both in a position of power. Your Honour, we submit that the second element is satisfied, as the police promised Mr. Smith a decent feed and rest only if he got the interview over and done with. Your Honour, my final omissions regarding admissibility, I would like you to consider Section 418 and 419 of the Police Powers and Responsibilities Act. While the officers did not err in communicating to Mr. Smith that he could contact a lawyer, they did err in not notifying him that his mother had engaged a lawyer on his behalf before commencing the interview. Unlike the Playford case, Mr. Smith was exhausted, starving, and riddled with anxiety. Promising him food and rest the interview be over and done with would induce him to make omissions he did not mean. Additionally, he was unaware that his mother had contacted a lawyer on his behalf. It was evident he was not in a clear state of mind. Your Honour, as per the Doyle case, Mr. Smith's omissions were not voluntary, as the police officers induced him by way of a promise. Your Honour, we submit that the omission should be made inadmissible based off statutory breaches of Section 418 of the Police Powers Act, Section 10 of the Criminal Law Amendment Act, and Section 418 and 419 of the Police Powers and Responsibilities Act. If Your Honour were to find the evidence is admissible as a matter of law, I now turn to submissions in relation to the discretions found in Bunning and Cross and Christine Crown cases. Firstly, Your Honour, my submissions as to the public policy discretion and Bunning and Cross. Your Honour has the discretion to reject evidence if you find it was obtained illegally or by some means that the law should not countenance. Your Honour, we submit the following as breaches of public policy and seek to have all omissions not submitted on this basis. Failing to tell Mr. Smith that he had a lawyer and promising food and rest to Mr. Smith when he was exhausted, starving, and in an anxious state. Your Honour, I cannot speak to what the police officers were thinking when they decided not to tell him that he had a lawyer. It may be that it was a genuine mistake and not deliberate. Hence why this particular element suggests that discretion should be exercised in this way. However, in my submission, what is much more important is the application of the following elements. The police were aware that Mr. Smith was exhausted and starving and in an anxious state before commencing the interview. They promised him a decent feed and sleep because of it, just to get the interview over, but he had to get the interview over and done with. Although this is a serious offence, there was no urgency to gain the omission. The police had Smith in lockup, he was not going to destroy any evidence, and they could have given him food and or rest before interviewing him. I hope Your Honour finds the police acted out of convenience rather than necessity. In my submission, it would be more appropriate for the court in deciding on the exercise of this discretion and put weight on this element. Whilst the gravity of the charge is not slight, the breach of public policy is also not slight. Had the police communicated with Mr. Smith that he had a lawyer and not questioned him whilst he was in the state that he was in, he may not have made the omissions that he has made that now will adversely affect him at trial. Your Honour, we ask you to use Bunning discretion and consider the effect on the public interest when the police do not have consideration for basic needs and disregard the accused's rights by not telling him he has a lawyer. As per Petroleus, the question, do the methods that were used to obtain the evidence fall below the minimum standard that society expects from those entrusted with law enforcement powers should be contemplated? We submit that not notifying the accused that he has a lawyer is below the minimum standard. Your Honour, the evidence in contemplation may have probative value for the Crown. However, we submit that when applying the Bunning and Island discretion, it is prejudicial to the accused and the public interest in law enforcement. Secondly, Your Honour, my submissions as to the unfairness discretion found in Christie and Crown. We seek to have the following omissions removed from the evidence based off the unfairness discretion. Smith's admission to planning to sell cocaine, Smith's admission to causing GBH under Section 320 of the Criminal Code, and Smith's admission to attempting to destroy evidence and the unlawful misconduct with regard to the corpses. Section 130 of the Evidence Act gives the court the power to reject evidence if the court is satisfied that it would be unfair to the person charged to admit the evidence. Your Honour, the fairness discretion in Christie and Hassler can apply when making a decision. These omissions may not be slight or insubstantial. However, Your Honour, I will direct your attention to the second limb of the Christie test and similar tests discussed in Hassler. Your Honour may exclude evidence if it is also if it has substantial prejudice against the accused, where the evidence shows discreditable conduct other than those facts which directly tend to prove the offence itself. Evidence would show, if accepted, that the respondent had been guilty of criminal acts other than those that are subject to the court upon which he is being tried in particular the criminal acts in relation to the murder of the two people. These omissions do not hold much evidential value as they do not directly relate to the elements required of a murder charge. The jury will likely give more weight to these omissions than it deserves. Therefore, Your Honour, it would be unjust to include these omissions in evidence as it would have a prejudicial effect on Smith during the trial, which outweighs their true evidential value. Your Honour, removal of this evidence would not damage a prosecution's case. In conclusion, Your Honour, the order we're seeking is for the omission to be excluded on the basis that it is inadmissible. If Your Honour does not find the evidence inadmissible, we then submit the Honour exercise discretion regarding the public policy discretion in Bunning and Cross and the unfairness discretion in Christie to remove the evidence from trial. Unless there is anything further that I can assist you with, Honour, those are the applicants.